The Senate Judiciary Committee hearing room fell into tense silence as Senator Lindsey Graham's gavel struck the wooden podium with commanding authority. His steely gaze fixed upon Congresswoman Jasmine Crockett, who sat composed at the witness table, facing the veteran senator who had dominated Washington politics for over 2 decades. At just 43 years old, Crockett was about to face one of the most aggressive interrogations in recent Senate history over her proposed voting rights legislation that threatened to upend decades of established electoral procedures. Congresswoman Crockett, Graham began, his distinctive South Carolina drawl carrying the weight of institutional authority. Your so-called voting rights bill represents a dangerous federal overreach that would destroy the constitutional foundation of American elections. You're asking this committee to support legislation that you clearly don't understand, and that would fundamentally undermine states' rights and election integrity. The packed gallery of voting rights advocates, constitutional scholars, and political observers held their breath as Graham continued his withering assessment. Your inexperience in federal election law is evident in every provision of this misguided proposal. Instead of the defensive response Graham expected, Crockett calmly opened her comprehensive briefcase and withdrew a thick legal analysis bound in leather. "Senator Graham," she replied, her voice steady and unwavering, "I've prepared extensive documentation that will demonstrate not only why this legislation is constitutionally sound, but why it addresses systematic voting rights violations that have persisted for decades despite repeated federal intervention." What happened next would shock the Senate, stun voting rights experts, and prove that sometimes the most formidable expertise comes from those who have lived the very problems they seek to solve. Before we reveal how Jasmine Crockett's devastating knowledge of voting rights law completely dismantled Lindsey Graham's opposition, make sure you subscribe and hit that notification bell, because what you're about to witness will change everything you thought you knew about voting rights and constitutional authority. Senator Lindsey Graham had built his reputation over 29 years in Congress as one of the most skilled interrogators and constitutional experts in Washington. At 69, his experience spanning the House Judiciary Committee during Clinton's impeachment and decades on the Senate Judiciary Committee had made him a formidable presence in constitutional debates. Graham's deep knowledge of election law had positioned him as the leading conservative voice against federal voting rights expansion. His opposition to Crockett's legislation had been fierce and public. In multiple media appearances, Graham had characterized her bill as radical federal overreach by someone who doesn't understand the first thing about election law. His confidence stemmed from his belief that a freshman representative couldn't match his decades of constitutional experience. Congresswoman Jasmine Crockett's path to this moment had been shaped by experiences few in Washington understood. After graduating from Prairie View A&M and the University of Houston Law Center, Crockett had spent 7 years specializing exclusively in voting rights litigation, representing plaintiffs in federal court challenges to discriminatory election practices across the South. What made her particularly dangerous to opponents was her combination of legal expertise and lived experience with voter suppression tactics. The confrontation over voting rights had been building for months since Crockett introduced the Federal Election Access and Integrity Act, comprehensive legislation establishing national standards for voter registration, early voting, and ballot access while strengthening protections against discriminatory practices. Graham had immediately positioned himself as the bill's chief opponent, characterizing it as unconstitutional federal overreach. "The Constitution is clear," Graham had declared in a recent viral Senate speech. "Election administration is a state responsibility, and Representative Crockett's bill would destroy that fundamental principle." But Crockett's legislation had gained unexpected support from constitutional scholars across the political spectrum, creating a rift in traditional opposition to federal voting rights legislation. As the hearing began, the stakes extended far beyond a single piece of legislation. If Graham succeeded in discrediting Crockett's constitutional reasoning, it would effectively end federal voting rights expansion. If Crockett could defend her legislation against Graham's challenges, it would open the door for the most significant voting rights advance since 1965. Graham had prepared extensively, consulting with conservative constitutional scholars and assembling what he believed were devastating critiques of Crockett's proposal. What he didn't anticipate was facing someone whose expertise in voting rights law matched his own, backed by both academic credentials and practical litigation experience. "Congresswoman Crockett," Graham continued with the confidence of someone accustomed to dominating hearings, "let's start with the fundamental constitutional problem with your legislation. The Constitution grants states broad authority over election administration, and your bill would usurp that authority in ways that violate basic principles of federalism and separation of powers." He leaned forward, his voice carrying decades of prosecutorial experience. "Section 3 of your bill requires states to provide at least 15 days of early voting. Section 7 mandates automatic voter registration, and Section 12 prohibits certain forms of voter ID requirements. These provisions represent unprecedented federal interference with state election operations that the Supreme Court has consistently protected from federal overreach." Crockett remained perfectly composed despite Graham's aggressive tone. "Senator Graham, I appreciate your concern for constitutional principles, which are indeed the foundation of effective voting rights protection. However, before we discuss federalism, I'd like to examine the specific constitutional authority that supports federal election standards and the Supreme Court precedent that validates the approaches in this legislation." She referenced her prepared materials with practiced precision. "I'd like to begin with the Constitution's Elections Clause in Article 1, Section 4, which grants Congress explicit authority to regulate the times, places, and manner of federal elections. Then examine how the 14th and 15th Amendments expand that authority to protect voting rights from state-level discrimination." The reference to specific constitutional provisions caused several committee members to look up with interest. Crockett was not simply defending policy preferences but building a systematic constitutional argument that demonstrated deep knowledge of federal election law. "The Elections Clause," Crockett continued, "grants Congress broad authority to override state election regulations when necessary to protect federal democratic processes. In Arizona versus Intertribal Council, the Supreme Court reaffirmed that this authority includes the power to establish national standards for federal election administration when state practices threaten democratic participation." She turned to another section of her analysis. More specifically, in Northwest Austin Municipal Utility District versus Holder, the court acknowledged Congress's broad authority under the Reconstruction Amendments to address voting discrimination through prophylactic measures that establish national standards for election access. Graham interrupted with visible skepticism. "Congresswoman, those cases address narrow federal authority over specific discriminatory practices, not broad federal control over routine election administration like early voting periods and registration procedures. Your bill goes far beyond addressing discrimination to federalizing standard election operations. It was exactly the challenge Crockett had anticipated. Senator Graham, I appreciate that distinction, which is why I'd like to examine how the specific provisions in this legislation relate to documented patterns of voting discrimination and access barriers that federal courts have consistently found to violate constitutional voting rights. She produced comprehensive data that would transform the hearing's direction. The 15-day early voting requirement in Section 3 responds to documented evidence that states with limited early voting periods create disparate impacts on minority and working-class voters, as established in federal court decisions, including Ohio Democratic Party versus Husted and League of Women Voters versus Newby. The automatic registration provision in Section 7, Crockett continued with growing authority, addresses systematic barriers to voter participation that federal courts have found to disproportionately affect protected classes. In Frank versus Walker, the Seventh Circuit noted that registration barriers create unconstitutional obstacles to voting rights that Congress has authority to address under the 14th and 15th Amendments. Graham's expression had shifted from confident authority to engaged surprise as he realized Crockett was citing specific federal court decisions with remarkable accuracy. Congresswoman, while your legal research appears thorough, the fundamental issue remains federal overreach into areas traditionally reserved to state authority. Senator Graham, that's precisely why I'd like to address the constitutional balance between state authority and federal voting rights protection, Crockett responded. In Shelby County versus Holder, while the court struck down the pre-clearance formula, it explicitly reaffirmed Congress's broad authority under Section 2 of the Voting Rights Act to address voting discrimination through appropriate remedial measures. She referenced another section of her comprehensive analysis. The court in Shelby County noted that the 15th Amendment commands that the right to vote shall not be denied or abridged on account of race or color, and it gives Congress the power to enforce that command. This legislation uses exactly that authority to establish prophylactic measures that prevent the discriminatory practices the court acknowledged remain problematic. The dynamic in the committee room had transformed significantly. Graham, who had entered expecting to overwhelm a freshman representative with constitutional expertise, now found himself engaged in sophisticated legal debate with someone who demonstrated mastery of voting rights precedent that impressed even veteran staff attorneys. Congresswoman, Graham said, his tone notably less dismissive, while your constitutional arguments are more developed than I expected, there remains the practical issue of enforcement. Your bill creates federal oversight mechanisms that would effectively transfer election administration from states to federal bureaucrats. Crockett's response revealed the depth of her practical experience. Senator Graham, I appreciate that concern, which is why this legislation carefully balances federal standards with state implementation flexibility. Section 18 allows states to maintain their own election procedures as long as they meet minimum federal standards for access and non-discrimination. She displayed implementation frameworks that demonstrated extensive policy development. Rather than federal takeover, this creates a floor of voting rights protection while preserving state authority over election details like specific procedures, technology choices, and administrative structures. It's modeled on successful federal-state partnerships in areas like environmental protection and civil rights enforcement. Furthermore, Crockett continued, the enforcement mechanisms in Sections 22 through 25 rely primarily on judicial review rather than administrative control. Federal intervention occurs only when courts find constitutional violations, preserving both state authority and judicial oversight that respects separation of powers principles. Graham leaned back, clearly reassessing his approach. Congresswoman, I'll grant that your legislation is more carefully crafted than typical federal voting rights proposals. However, the political reality is that this represents a dramatic expansion of federal election control that many states will view as constitutional overreach. Senator Graham, I understand those political concerns, Crockett replied respectfully, but I'd like to address why constitutional voting rights protection requires federal action despite state opposition. She turned to what would become her most powerful argument. In South Carolina versus Katzenbach, the Supreme Court noted that federal voting rights enforcement becomes necessary precisely when state resistance prevents constitutional compliance. The court stated that Congress may use any rational means to effectuate the constitutional prohibition of racial discrimination in voting. She continued with remarkable authority. The documented evidence supporting this legislation shows that 23 states have enacted voting restrictions since 2020 that federal courts have found to create disparate impacts on minority voters. This pattern of systematic resistance to voting rights protection demonstrates exactly the circumstances that justify federal intervention under Katzenbach and its progeny. Graham attempted one more constitutional challenge. Congresswoman, even accepting federal authority over discrimination, your bill addresses practices like early voting and registration procedures that affect all voters equally, not just protected classes. Crockett's response demonstrated both legal expertise and lived experience. Senator Graham, that's exactly why I'd like to address how seemingly neutral election practices can create discriminatory effects that require federal intervention. She produced statistical analyses that would fundamentally shift the debate. Research documented in the legislative record shows that working class and minority voters are disproportionately affected by limited early voting, restrictive registration procedures, and inadequate polling access. In Texas, Democratic Party versus Abbott, federal courts found that these neutral practices created unconstitutional barriers to voting rights that required federal remedy. The beauty of this legislation, Crockett continued, is that it addresses these disparate impacts through universal access improvements that benefit all voters while specifically protecting constitutional rights. It's not preferential treatment. It's equal protection through expanded access. She displayed comprehensive data showing voting patterns across demographics. States with robust early voting and accessible registration show higher participation across all groups, but the largest increases occur among historically disenfranchised communities. This legislation creates equal opportunity for democratic participation rather than equal barriers to voting rights. Graham, who had spent decades opposing federal voting rights expansion, found himself in the unusual position of acknowledging the strength of constitutional arguments he had come to discredit. Congresswoman Crockett, while I maintain concerns about federal overreach, I'll acknowledge that your legal analysis is more sophisticated than typical voting rights proposals. He paused, clearly weighing his words carefully. Your documentation of disparate impacts and your constitutional framework for federal intervention demonstrate serious legal scholarship that this committee needs to consider carefully. The admission represented a remarkable shift from Graham's opening attack on Crockett's qualifications and constitutional understanding. Committee members exchanged glances as they recognized the significance of Graham's acknowledgement that his initial dismissal had been premature. "Senator Graham," Crockett responded with quiet dignity, "I appreciate your willingness to engage with the constitutional arguments rather than dismissing them based on assumptions about my experience or qualifications." She organized her materials with practiced precision. This legislation represents 5 years of research into voting rights violations, consultation with constitutional scholars across the political spectrum, and careful attention to both federal authority and state implementation concerns. It's designed to protect constitutional voting rights while respecting federalism principles that you and I both value. The goal isn't federal control of elections, it's federal protection of the constitutional right to vote that states are constitutionally obligated to respect, but sometimes fail to provide. As the hearing moved toward conclusion, Graham made one final attempt to challenge the legislation. "Congresswoman, even accepting the constitutional authority you've outlined, the practical effect of this bill would be to override state voter ID laws and registration requirements that many citizens view as necessary election security measures." Crockett's response revealed both her legal expertise and political acumen. "Senator Graham, that's exactly why Section 15 of the legislation includes robust election security provisions that address concerns about fraud and irregularities while maintaining access for legitimate voters. The bill requires states to implement paper ballot backups, post-election audits, and cybersecurity standards that actually strengthen election integrity beyond what most states currently provide. Rather than eliminating security measures, it creates comprehensive security frameworks that protect both access and integrity. She displayed security provisions that had received endorsements from election security experts. Former Republican and Democratic election officials have noted that this legislation provides more robust security protections than current state laws while eliminating barriers that prevent legitimate voters from participating. Graham's final question revealed how thoroughly the dynamic had shifted. "Congresswoman Crockett, given your obvious expertise in this area, what would you say to conservatives who worry that federal voting rights expansion represents the first step toward federal control of all election operations?" "Senator Graham," Crockett replied, "I'd say that constitutional voting rights protection actually strengthens democracy in ways that conservatives should support." Her answer demonstrated both constitutional knowledge and political wisdom. When every eligible citizen can vote easily and securely, election outcomes better reflect the will of the people rather than the effectiveness of voter suppression tactics. Constitutional democracy works best when participation is maximized and barriers are minimized, which should be a bipartisan goal, she concluded with quiet authority. This legislation protects the fundamental conservative principle that government derives its authority from the consent of the governed. Federal voting rights protection ensures that consent is genuine rather than the result of discriminatory barriers to democratic participation. As the hearing concluded, observers recognized they had witnessed something extraordinary. A freshman representative had successfully defended comprehensive voting rights legislation against constitutional challenges from one of the Senate's most experienced interrogators, using legal expertise that transformed the entire debate. Graham's closing statement acknowledged the shift. While I maintain concerns about federal expansion into election administration, Congresswoman Crockett has presented constitutional arguments that deserve serious consideration from this committee and the full Senate. Within hours, voting rights experts began analyzing what they had witnessed. Harvard Law School's election law clinic called Crockett's defense a masterclass in voting rights jurisprudence, while the Brennan Center noted her sophisticated understanding of federal election authority. Conservative legal scholars found themselves acknowledging the strength of her constitutional framework. The hearing's impact extended far beyond immediate legislative prospects. Law schools reported increased enrollment in voting rights courses. The case became a model for how sophisticated legal analysis could transform political debates from partisan opposition to substantive constitutional discussion. 3 weeks later, Graham surprised observers by announcing support for modified versions of several provisions in Crockett's legislation. His statement acknowledged that Representative Crockett's constitutional analysis has convinced me that federal voting rights protection, when properly structured, strengthens democratic governance. 6 months later, Crockett addressed the Federalist Society's annual convention on constitutional voting rights. In her speech, she emphasized that constitutional expertise isn't partisan. It's about understanding how our founding principles apply to contemporary challenges. The confrontation between Graham and Crockett became a landmark example of how expertise and constitutional knowledge could transform political opposition into policy collaboration. What began as an attempt to humiliate a freshman representative had instead demonstrated that the most effective constitutional arguments emerge from those who combine legal expertise with lived experience of the problems they seek to solve. The voting rights expert had proven her constitutional mastery through rigorous application of legal knowledge that even her strongest opponents could not ignore.